So it is my pleasure to introduce our final presentation of the day. As I said, our speakers Ryan Breeden and David Lackman will present on the Fortune trial. Jessica Gluckstein, a lawyer at Gluckstein Lawyers, will moderate this discussion. Ryan is the founder and principal of Breeden Litigation and has tried cases before judges, juries, arbitrators, and administrative panels all over Ontario, with expertise in many areas, including medical negligence. David Lackman is a senior lawyer with Gluckstein Lawyers. His litigation practice now extends over 35 years, encompassing serious and complex personal injury and disability claims and wrongful death claims. David has achieved outstanding results against some of the country's largest corporations, including, well, there's a big list, but so I'll leave it at that. Welcome to the stage, everybody, and thank you so much.
Okay, thank you, everybody. For those who don't know me, as Brenda said, I'm Jessica, and I am one of the associates in our medical malpractice group. And up here today with me are Ryan and David, who I have the pleasure of assisting during this Fortune trial, which we'll be speaking about today. Before we get into any of our panel discussion, Ryan, are you able to just give us a really brief overview of the case?
I am. Do we have your slide that you prepared?
Hopefully.
Anyways, so the slide will come up. Plaintiff has a slip and fall at Walmart on Christmas Eve. Christmas Eve, I think.
Boxing Day.
Boxing Day. All right. And she suffers a profoundly dislocated knee, so very obvious to everybody. And that injury has a high risk of a chance of an injury to the arteries behind the knee, which in fact happened to this poor woman. She's taken to Humber River Hospital, where she is seen by an emergency room physician, defendant number one, Dr. Leanne. He performs a reduction, which is the appropriate step for the standard of care of the dislocated knee, performs a vascular assessment of the injured leg, but importantly, as we'll see, not the non-injured leg. He then does a telephone consult with the orthopedic surgeon on call, defendant number two, Dr. Lai, who says everything is fine and that it can wait until the morning. About 1 o'clock in the morning, the patient began to experience very marked pain and other symptoms. The nurses asked Dr. Leanne to come back and reassess the patient. He testified that he was suspicious of compartment syndrome. He loosened the bandages and then did nothing further. The patient continued to deteriorate over the night. At about 6 a.m., it was noted that she'd lost essentially all pulses in the leg, and ultimately she suffered an above-knee amputation. So we sued the Walmart, as David's going to talk about, the hospital, and both of the physicians. And by trial, and I think we'll come to this, only the two doctors were left standing.
Great. So one of the biggest themes that we saw throughout the trial, which came through, I thought, so clearly in the decision of Justice Vermette, was the topic of difficult experts and the role of expert evidence at trial. Ryan, if you don't mind again, if you can chat with us a little bit about your experience with the expert witnesses during trial and their impact on the outcome.
Yeah, so and we're talking in particular about the witnesses called by the defense. They had 3 expert witnesses. Damages had been settled. So 2 standard of care experts, one for the emergency room physician, one for the orthopedic surgeon, and then a causation opinion. The causation expert was fine and there were no issues and actually had substantially the same opinion as our own expert, at least by the end of the trial. The 2 standard of care experts called by the defendants were astonishing. I once did a trial when I was defending one of these cases, where the plaintiff's expert in a radiology case ultimately admitted that he himself had breached the standard of care. These guys were worse than him by a huge margin. And it's extraordinarily difficult. in the case of the orthopedic expert, it was a fellow named Dr. Paidich, who has testified many, many times, not in medical malpractice cases typically, but in motor vehicle accidents, workplace injury, those sorts of forums. And so there were a lot of transcripts floating about him, and I had some sense of what to expect with him, and he delivered exactly as I expected. And in terms of dealing with these things, I think actually some of the comments that you've heard earlier today really bear witness. One, I agree with Todd completely that preparation is absolutely key for these cases, both in terms of having a plan and executing the plan, but also preparing for the vagaries of what might happen, right? And you think about, if I ask this question to the expert, what are the possible things that they might say? And you need a plan for all of those possibilities, or maybe you ought not answer the question. You can practice if I run the examination this way, or if I run the examination that way, so you have a sense of what your tone is going to be, what your delivery is going to be. All those things that Todd was talking about, I think, are actually really important. And also, it means that you're not caught flat-footed when the expert goes completely off script, as the experts did in this case. The other piece of it is that you absolutely have to have a complete command over the subject area. So I do a lot of advocacy teaching. We teach the Intensive Trial Ad, and I teach at Osgood, and lots of those things. And we often say to students, when you're dealing with an expert witness, you don't want to engage them on the area of the expertise, because they are going to know more about it than you. And if you get into the weeds on the minutia of their specialty, you're going to have a problem. I would suggest that in these cases that is not true. That in these cases, if you are going to take one of these cases to trial, you must be prepared to wade into the minutia of the details, including the literature, including oftentimes, if they've cited a summary article or something, all of the articles that were cited underneath, understanding exactly what it is that they're saying, because you're going to need potentially to get into the weeds with the expert in order to show that the opinion is not accurate. And that's exactly what we had to do in these cases with respect to both of the standard of care opinions. And so you'll see, if you look at the decision, the Justice Vermette quoted pages and pages of the cross-examination of expert number one, and ultimately refused to accept his opinion because he would not adopt things that were plain and obvious based on his own admissions. Expert number two, she didn't quote, but accepted ultimately that he was, the word that came out of my mouth apparently in closing argument was deplorable, and that was how she described him. And he's never going to testify again, thank God. But it's really only because of being willing to do the dance in terms of the actual medicine and the literature and all of the rest of it. The other thing is really important, another thing that I think Todd mentioned, is you got to keep your cool with these guys, right? It's easy to get flustered or upset, and you really can't do that. And as Duncan said, you have to be prepared to take these people to task. Like, you can't just let them give their opinion and then hope you will be able to persuade the judge at the end, well, my expert was the better or the more convincing expert. You have to be prepared to go right into the ring with them and go for the knockout punch if at all possible, right?
So another interesting element in this case was the use of pair-injure agreements. David, hopefully you can chat with us a little bit about what these agreements are, how they're used, how they were used specifically in this case, and perhaps some of the risks that are associated with that.
Okay. First of all, the trial took place in April and May of 2022. We didn't get a decision, I think, until late December or January of this year. There were two pair-injure agreements that were entered into in this case. One was with Walmart, and that was about 3 weeks before the trial actually started. The other was with the hospital defendants, just a matter of days before the trial. So given the time constraints, I'm going to just talk about the pair-injure agreement with Walmart, which is, in my view, the more interesting of the two, at least for discussion purposes, although both pair-injures contain similar terms. So briefly, what is a Paringer agreement? The terms of these agreements are typically fairly elaborate, but the simplest way to describe Paringer, which originated back in the US about 60 years ago and was imported into Canada, I think it was 1995, is that this type of agreement permits one or more of the defendants in a multi-defendant proceeding to settle with one or more of the plaintiffs. The settling defendants then completely withdraw from the litigation, which is, I don't mean to get too technical, but it's what distinguishes a Paringer from a Mary Carter agreement, which many of you might have been familiar with. Now, this leaves the remaining defendants, known as the non-settling defendants, responsible only for the losses attributable to their own liability, if found. Those non-settling defendants, therefore, are no longer jointly liable with the settling defendants, but of course they may still be jointly liable as between themselves. Now, what are some of the risks and challenges associated with the use of a Paringer? Since the court must still assess the liability of the settling defendants, even though they're no longer in the action, at least in our case that was the case, what if liability is assessed against the settling defendants in a significantly greater proportion, or against the non-settling defendants in a significantly lesser amount than the plaintiff had contemplated when this Paringer settlement agreement was made? What if there's an agreement on damages with the non-settling defendants, and the lion's share of the damages is found by the court to be attributable to the defendants with whom the plaintiff had settled for only a fraction of those damages? Now, applying that to our Fortune case, in which we had Paringered with Walmart and had an agreement on damages with the non-settling doctors, what if the court had found that Walmart was, for example, equally liable with the doctors, yet the settlement with Walmart was for an amount that was significantly less than 50% of the agreed damages? The shortfall to the plaintiff would be substantial, for which the doctors would not be responsible. They're out of the action. I'm sorry, they're in the action, but their liability is strictly with respect to them. It's not joint. Well, fortunately, as it turned out, the court assessed zero liability against Walmart in our case, so that the full measure of the agreed damages was paid by the doctors, offset only by the amounts received by the plaintiffs under the Paringer agreements with both Walmart and the hospital. So you can see how carefully, therefore, one has to tread when considering a Paringer, given how the assessment of the liability exposure of the settling defendant, and therefore the amount that you settle with that defendant, could seriously miss the mark once the court determines liability, because you don't know how the court is ultimately going to determine that. So you need to be realistic, first of all, in your assessment of the potential liability of the settling defendants, and you absolutely need informed instructions, which clearly we had in this case, from your client, meaning a fulsome explanation of the potential risks before you even enter into Paringer territory. Now, another important consideration is that these agreements, these Paringers, can't be made in secret. While the settlement dollar amount need not be disclosed to the non-settling defendants or to the court while the case is ongoing, the settling parties must disclose the existence of the settlement agreement where that Paringer changes the adversarial orientation of the lawsuit. Now, in our case, in Fortune, that is precisely what happened when we struck a settlement deal with Walmart. The adversarial orientation changed significantly as a result of the agreement with Walmart. Now, as you'll hear in a moment, we as plaintiffs' counsel were suddenly cast in the role of having to defend Walmart Remember, we had sued Walmart, claiming that it had breached the required standard of care as an occupier. We discovered Walmart's representatives. We had scrutinized their productions, all with a view towards establishing a breach of the OLA, the Occupiers Liability Act, by Walmart, resulting in our client's catastrophic injury. So we started off the case suing Walmart. And it was an aggressive approach, which was required against Walmart because we had an amputee client and a medical malpractice case, which, like most malpractice cases, we expected would be very vigorously defended and would present challenges as to both liability and causation. And we were, in a word, adversaries of Walmart right up until about 3 weeks before trial. Then, having settled with Walmart shortly before the trial, and with the court still having to assess Walmart's liability, if any, we found ourselves in what would probably be considered the odd position of having to defend Walmart's actions and deflect as much liability away from Walmart and onto the doctors as much as we could, hence the change in adversarial orientation. Now, at trial, we chose to call a few witnesses, several witnesses, from Walmart's managerial staff as our own witnesses, and use their available evidence and the productions to make argument that Walmart had instituted and enforced reasonable policies and procedures for the inspection and maintenance of the premises, and thereby met the standard of care required under the OLA, the complete opposite position